All right, good evening. It is 7 o'clock, so we'll go ahead and get started tonight. We have the City Council Caucus meeting tonight. I'm going to rearrange the agenda just slightly, and we're going to flip the certificate of need to the top of the agenda because more of the discussion amongst council members will happen with the flagship. Councilman Hermes, if you'd like to take the lead.
Yes, thank you, Mayor. I received a call from our state rep from the 60th District, Mary Ann Proctor. She asked to speak to our council regarding legislation that she has proposed regarding the certificate of need, and she is here in the audience this evening, and I'd like to welcome her up to the podium to speak. You'll just hit that little orange button to talk there.
Thank you so much for having me, particularly on short notice. As Tyson said, I am Mary Ann Proctor. I am the representative of the 60th District, which encompasses most of Union and portions of Florence. I'm here tonight. My background is I've worked in healthcare for 20 years. I worked primarily in the medical center in Houston, Texas, in probably one of the finest medical institutions in the nation. So I feel like I have a little bit of background on this, a little bit of expertise to speak to the certificate of need. So I am a freshman legislator. When I ran this year, I knocked a lot of doors. And probably the top two concerns I heard from my constituents is what we need some choices in healthcare. A lot of people were disappointed with the quality they received, how long it was taking them to see physicians, and for all the needs that came up, they felt like it was taking too long to be seen or that they weren't adequately being addressed. So I listened to them, and I did run House Bill 312 this year, and what that does, it repeals certificate of need for our tri-county area, for Boone, Kenton, Campbell County. If you look at our population, we are much larger than Lexington that has multiple hospital systems. And yes, Louisville is bigger than we are, but again, they have multiple hospital systems. I believe that when people have choices, that informed people can make those decisions, and we don't have that in Northern Kentucky. This is not a personal slam or any vendetta against St. Elizabeth's. I know many physicians there. I have many friends and nurses there. I myself have received health care there. It's not a personal vendetta. I think that message has been misconstrued. That's not at all what it is. The people are asking me for choices. So when I was running this bill on the floor, many of my colleagues are like, that's great, but why are you only doing it for Northern Kentucky? Part of why I was only doing it for Northern Kentucky, in Kentucky, we have 23 restrictions on what type of services can come into Kentucky. Things that range from imaging, MRI, PET scans, things like that, hospice, ambulatory surgical centers, substance abuse, mental health abuse or issues. There are so many of those things that are restricted that you have to demonstrate to the state, go through a lengthy application process that's costly, and then have people vote on, and many times those people that have control over the yes or no, can somebody come in, it's a conflict of interest, as we have seen in the past. So for me, when we go across to Ohio, for many of us, it's not super far. Ohio has one restriction of need, which is long-term care facility. Our friends over to the other side, Indiana, they have one on the certificate of need restriction, which is long-term care. Tennessee, in 2021, they repealed most of their certificate of need, except for, I think they're down to 6. So we have recently, in the legislature, been restructuring our entire tax code system to be more competitive with Tennessee. My argument is, why aren't we doing that with our health care? Why are we limited to one service? And if you want to have different, you've got to cross the river. My argument is, why are we not keeping those health care dollars here in Kentucky? And why can't we have choices? So a lot of my colleagues have asked that. The bill did not get picked up, wasn't a legislative priority for this session. However, we did file concurrent resolution, also with Jay Williams, a senator, and he and I are hoping to get, which we've been told by leadership, a task force this summer to study certificate of need and to have an honest discussion about, is it time to allow other entities, if they want to choose to make that choice, to come into Kentucky without having these significant barriers and hurdles for them. So unbeknownst to me, the mayor in Fort Wright put out a resolution asking to repeal certificate of need. I thought that was rather interesting, so I had a conversation with him, and I've been having conversations with mayors across Boone, and they're very much in agreement of it. Certainly down in Union, we've got Children's coming in, which is limited services, but for these families that have to go all the way up to Children's way up in Ohio, for a lot of people, that's not feasible. They would love to have those services here that are closer. So that's all that we're asking for. We're asking for cities to, would you consider, look at certificate of need and maybe perhaps consider repealing it so that our people are able to have more choices. And if you have questions or, yeah, Tyson.
So we recently had Representative Doan come and talk to our council, and he was asking for us to produce a similar resolution. I think that's what Marianne is asking of us this evening. I don't know, is it possible for us to get a straw poll, if that's something that council would support?
I think there were some other questions, and then we could do a straw poll after all the questions are done.
Great.
If that's okay. Ms. Jasper Lucas?
I have some comments and some questions. This is something that I worked in healthcare many years ago, and that's the first time I'd ever even learned about this process. And I thought to myself, this is so archaic. This is such a barrier to services for everyone throughout the whole state. So I do have the question of why not the whole state, but you also kind of already answered that. I hope that if it passes, that it will carry over to the whole state, because there are some rural areas, I feel like, that lack services as well. And I think that removing the certificate of need process would allow, obviously, providers to come into those areas too, where people are waiting to get MRIs and CTs and things like that, which sometimes creates a situation where they're also waiting for care that they need, and it's ridiculous. It shouldn't be happening. It should not be happening in 2023. So that was really all I wanted to say. I feel like it's always been a barrier to new providers coming in. We have such a huge need for mental health services, inpatient mental health services, and if we don't have those beds because of this process, that's a barrier to people getting help, and that's not okay. It's just not okay. So I'm completely in support of this. I hope that if my fellow council members, because it's kind of a confusing process, I think. So if you don't understand it, please, ask the questions, educate yourself, because it is a confusing process. And I just really don't think the general public, they understand that they want competition, but I don't think they understand why that's not happening. And it needs to happen. So that's all. Thank you.
Any other questions or comments? Okay. So I guess I just need a straw poll from you all to determine whether or not we want to create a resolution and put it on the April meeting. If you are for the resolution in support of Mary Ann's endeavor, please raise your hand. Okay. All right. So we'll go ahead and I'll ask Mr. Gatlin to draft something and have it prepared for the April 4th meeting. Okay, thank you.
Thank you very much. I appreciate it.
Okay, next item on the agenda is the Flagship Park Running Group. Councilman Hermes, if you'd like to start the discussion.
Yes, thank you, Mayor. I've put together a presentation. Okay, great. I'm going to go to the podium if you don't mind. Thank you again for giving me this opportunity. I wanted to talk a little bit more about the section of our code 9629 that references Flagship Park in our parks code. I will apologize for the starkness of this presentation. I'm sorry it's not more flashy or entertaining, but it's factual, and I try to hit everything. I'm trying to hit every part and aspect of this. It's going to be pretty boring for us that have been talking about this for the last 3 months or so, but I'm trying to make it so that if someone's just now tuning in about the issue, that they can understand at least my interpretation of the code. I haven't operated this before, so. Okay, great, thank you. Okay, the definition in our code of athletic teams is a group of persons recognized as a team by any league or any other group of athletic teams organized to compete against themselves. Okay, that's the way we explain it. Thank you, Kara. So the actual law itself says, nobody shall by act or omission conspire, cause, permit, promote, allow, assist. I swear, I think sometimes attorneys are paid by the word. Allow, assist, encourage, or engage in the use of Flagship Park in the city for organized practices by any member of an athletic team and games between athletic teams. Organized practices by any member of an athletic team and games between athletic teams. Okay, go to the next slide here. Okay, we've got some photos here, and as I go through this, I guess technically you could say, like in the bottom right hand, if those people played on an intramural basketball team together and they came to the park and were kicking a soccer ball, that technically wouldn't be allowed if you really wanted to parse it. And the more I read through this and the more as I went through this presentation, I think the biggest violator here is probably the group that's in the top right there. Organized, set rules, it's they're teams, it's chess. But anyhow, I digress. Let's go on. Next slide, please, Kara, thank you. So some of the history and the facts of the park here. So somewhere between 2015 and 2018, the Flagship Park sand volleyball court was used for pickup games on a regular basis. This was every week. I think it was Friday nights. To my recollection, there was no complaints about the parking, the noise, or the crowds. Hit that again, Kara. So the routine was interrupted by a colony of cicada killer wasps that decided to make nests in the sand and frightened the people away. Go ahead and hit that one more time. And you can see why. They're huge. The league found a new place to play and never came back. All right, let's move on. Some more history and facts. We encourage people to play bocce ball on the court at Flagship. This has a potential to be organized, but doesn't raise an eyebrow because it's likely less than 25 people, and parking has never been a problem for this. An interesting side note to this, under our current parks code, bocce ball is specifically not allowed because it uses a hard ball. And there's a part of our code that says only soft balls may be used in our parks. You're also not allowed to ride bicycles in our parks unless you're a police officer, according to the code. Okay, let's move on here, Kara. Stargazing at Flagship Park. Now, parking can be an issue for this since the telescopes are set up in the parking lot, but noise is not an issue. It causes the park to be used after hours, which is technically not allowed, but again is tolerated because it's infrequent, nobody complains, and the activity is dictated by nighttime. All right, more history and facts. Okay, yoga is currently encouraged in groups gathered in Flagship Park. It is athletic, it is organized. Is it a team? No, it's not a team. It's okay and encouraged because it's considered a group exercise. Parking, noise, and crowds have never been a problem, but the potentially certainly exists. Okay, let's move on. I could like hear your jaws dropping when you're seeing this awesome animation as these things are coming in. Okay, Shakespeare in the park. It's a city-sponsored event at Flagship. It's neither athletic or teams, but definitely organized and generates parking problems and noise. But it's for one night, and it's seldom, and I think everybody appreciates the diversion from the normal. All right, more histories and facts. We've got parties, families, groups, teams even, that have the ability to reserve the structures at Flagship Park. Noise, crowds, and parking can be an issue. The city clerk coordinates the reservations for this, screens the people coming and going. Next, we've got the fishing derby. Again, parking is definitely a problem when this happens. Again, it's a seldom occurrence, and it's only for a few hours on a weekend morning. All right, so the purpose of the law. One more, Kara. It was created back in 2010, and I think we can all agree, running groups were not the targeted offender or the reason that the law was created. Let's hit that one more time, Kara. Okay, so the law was created to control frequent crowds and noise that would be generated by practices or games of football, soccer, baseball, maybe even lacrosse or basketball. Whistles, cheering, singing, amplified voices, yelling, and of course the parking issues. We encourage these sports in almost all of our other neighborhood parks. All right. So what the law is not. The purpose of the law has never been to discourage the use of the park. It's never been to discourage exercise or cardiovascular fitness. It was never intended to reduce the number of people on the walking path or curtail social interaction. Hit that one more time. Quite the opposite. The purpose of the park is actually to promote all of those things. All right, next. Once again, Erlanger suffers from a poorly conceived ordinance. One more. As you know, one of my pet peeves is a carve-out of an ordinance for a specific group, person, thing, or incident. We currently have an ordinance that covers all of our parks, yet there's a carve-out, 9629 for Flagship Park because of an incident that happened back in 2010. I get it. The thought at the time was that everything could be solved or controlled with ordinances and new laws. In hindsight, this could have just as easily been controlled with signage and enforcement or a change to the entire ordinance. If we go back and we look at how many phone calls we've gotten, how many complaints we've gotten because people are organizing and playing sports at Flagship Park, I think it's, am I safe to say it's zero? Yeah, okay. So part of our issue is that carve-out. One more. So carve-outs. Recently, we wanted to create another carve-out of the carve-out for another special group, which is not clearly defined. That's the running groups. Much of the burden of the enforcement is placed on the shoulders of the city clerk, and that's simply not fair, or that could require additional staff. So here's my issue. Carve-outs lead to more carve-outs in city law. You know, if we allow running groups now, then how long is it going to be before we have somebody else call us and say, well, I've got something that I do there too, and it could be construed and blah, blah, blah. So legislators are always unable to see the future and many times unable to foresee the ramification of these small changes. All right, so my prediction is if we had passed the previously proposed change to, it's actually 9629, sorry for the typo there, it would have only led to more changes, clarification, and scrutiny in the future. This is great if our interest is to keep the city attorney busy. However, it distracts from the real duties of the city attorney, city staff, and this council. So the issues with the failed change, you know, we had one of the neighbors that came up and asked, what exactly would somebody be reserving? That's a great question, and we did not clarify that. You know, is it the whole park? Is it just the running path? It's not clarified. Once reserved, does the group have the right to tell others to vacate? That came up as well. We need those answers, you know. Next is, how big will the group grow? What if it grows to 500 runners or 1,000 runners? We really don't discuss that at all. You know, again, a lot of that's put on the shoulders of the city clerk. So the law is the surviving record. These things need to be addressed by the law, in my opinion, if we plan to make a change. The city policies for rental are more difficult to find and easier to manipulate over time. It's better to have it all in one place so councils of the future understand the intent without interpretation. So my argument is this. Running groups are allowed in Flagship Park under the current law. Running is an exercise. The intent is to promote physical fitness, endurance, cardiovascular health, and improve time. The difference, this is different than an athletic team, athletic sport, or organized sport. Next. So some of the definitions. Oxford defines team as a group of players forming one side in a competitive game or sport. The Western Gazette was asked the question, what separates a sport from an activity or a game? And their response was, in the most general definition, sports need to fill 3 requirements. There needs to be physical exertion or skill. There needs to be a competition between players or teams. And it needs to have a defined set of rules that the competition has to follow. All right? I would argue that our running group does not follow, it doesn't go by that third rule. So the issue is, unlike most things, that this issue was not brought to council by a concerned or unhappy citizen or neighbor. It wasn't brought here by a complaint. We actually heard testimony from many of the people who spoke spoke against the change to the ordinance, who said that they did not have a problem with this running group. The issue was brought before council by the coaches who wanted a provision of the law struck or provision added for a special interest. So the issue, while there certainly is a potential for parking issues in the park with this running group, we've not seen formal complaints generated from the surrounding community. I argue the running group is an organized activity, exercise activity, not an athletic team. We currently promote other exercise activities in the same park. So the conclusion is, so long as the group follows all the other rules of our parks, remains respectful to the other people using the park and walking trail, doesn't create excessive noise, and the parking issues don't generate complaints, and so long as it doesn't interfere with other city scheduled events, then the current law sufficiently covers this activity and doesn't require a change. I recommend we allow the running group to continue to use the park. I also recommend we master plan additional parking and a drop-off turnaround in the park. I also recommend this came up as one of the comments from one of the citizens, that we master plan a pickleball court into the park. So the action item, where do we go from here? The Parks Task Force will begin to work on a meaningful revision of the legislation that will treat all parks and all neighborhoods equally. Chapter 96 will no longer have a carve-out for Flagship Park. What makes Flagship Park different than our other parks? The legislation shall be written so that it's applicable to all parks. The next Parks Task Force meeting will be 5:30 on Tuesday, April 4th at the Public Works office. Please attend and give us your input. Any questions? I saw a hand raised over there. I think I saw yours first, Mrs. Reckers.
I appreciate you very much breaking this down and taking the ordinance piece by piece. I think it is very helpful, and I'm looking forward to being part of the working group to refine our parks ordinance. The only thing I want to clarify was it wasn't the coaches asking for a carve-out. It was upset parents calling members of council the night that a city employee, in error, misdefined a running group as an organized sport at the park. That is what escalated this, and that's why we crafted a potential carve-out of a carve-out of a carve-out in November for discussion. So that's the origin of the issue, just for, I don't want to put this on the coaches. It's not their fault. Thank you.
Do you mind if I step in and kind of give the follow-up of that? So this was brought to my attention the next day that this issue occurred, and the next day I said, they're fine. If we do not have any complaints, they are not a sports team, let them move forward. The issue was rectified within 2 hours of us being open for the day. So in my opinion, this didn't even need to happen, to be quite honest. The employee that had the conversation has had further conversations with, other employees. And we've talked about this ordinance and how to enforce it and who's to enforce it. So it's been handled. So this was rectified the next day. Ms. Jasper Lucas.
Thank you. Excuse me, thank you. I was going to say the same thing Ms. Recker said, just to clarify that. But the only other thing I want to clarify with the mayor is that you and I texted back and forth about this because we were both contacted by the same folks at the same time about what had happened. However, it was my understanding from you that, yes, they could practice until we got the ordinance changed. And I can go back in my text messages and look at that. But basically, the ordinance, we were interpreting it as they couldn't practice there. And we knew that they were in their existing season and needed to continue practicing, and we weren't going to be able to fix the ordinance. But my understanding from you was that we did need to change the ordinance. If that was not the case, I wish you had said something prior to now about that. But obviously this generated a lot of discussion. I don't think the discussion was all bad because I think we learned a lot about the usage of the park and maybe that we do need more parking. I'm not sure that would have come about had we not, had this experience. But the only other thing I'll say, and I'll never ever probably say it again, but I completely agree with everything Mr. Hermes said. And I think that the interpretation is completely accurate. And, if my neighborhood wants to have a walking group or a running group, there's no reason, we're not a team, we're not competing, but it is an organized group. And there's no reason why we shouldn't be able to use the walking path that's up there. And I've said this all along, our parks are for everyone. And I feel like this outcome supports that. And I'm thrilled with it. So, I hope that I plan to, attend the parks meeting as well and hope that we can create legislation for all of our parks that doesn't have these random exclusions, because I'm not for that type of legislation. I just don't think it's good. Thank you.
All right. Oh, Ms. Nicely.
Thank you, Mayor. Councilman Hermes, thanks for the PowerPoint and explaining the ordinance a little bit better. In the last couple weeks, I've been more educated on where all this started from, which I think at the beginning, a lot of pieces were left out. Now all the dots have been connected, and we're seeing it all make sense now. And I totally understand, and I am part of the Parks Task Force that will be meeting on this with several others. And I welcome everyone else to come, and we can sort this out, because we don't want the city torn, and we do want the kids to be safe, and we want the residents happy. So let's work on seeing what we can do to fulfill everybody's happiness. Thank you.
Ms. Wilson.
Thank you. I want to thank Councilman Hermie for explaining this ordinance, because I was clearly confused over the reading of the ordinance, and as you see, I have headsets on so that I can hear clearly, and I appreciate that. And I appreciate all the parents who have responded. I've got quite a few emails, and I appreciate that. I just want you to know that our children, and I include our children, are more important than grass and concrete. And I am a neighborhood mom, so I clearly agree that the park should be open for the runners to be able to run. Thank you.
Ms. Kyle?
This has been a very difficult issue for me because I was of the same opinion, and I spoke to Mr. Hermes before about this, and I told him, I said, you know, this group that runs, if they don't identify as a team, strictly speaking, by the ordinance, they're allowed to run. So why don't the moms just pick them up, take them up there, let them run, and be done with it? I mean, it's not like a team thing. So, and what I was afraid of too was like if you change the law, allow running groups or running teams, I think it said, I don't know what it said now, but athletic teams, then you're going to have soccer want to come up there and all kinds of stuff. So, but I would appreciate if people, and I'm sorry I didn't answer all your emails, but I got so many this week, it was unbelievable. But I would appreciate too if you would come to the parks meeting where we can all communicate. And thank you, Mr. Hermes, for that insight because you did a great job. That's fantastic. So hopefully we can get this ironed out because, like I said, and somebody else said, we had no complaints about that little team, no, not a team group. And, you know, if everybody had just done their thing and not said anything, it was okay because nobody was taking any offense to that. We just don't want big, giant teams coming up there and taking over the park. But if you're a running group, you know, hey, I'm sure there's groups in the neighborhood that, you know, ladies, men that get together on a regular basis and run for their exercise. And that's a group. So as long as you're not a team, we're okay. So I would appreciate people coming to the meeting. Thank you.
Anybody else? Ms. Skidmore?
I would like to know from the audience that's attended the meeting tonight if they're happy with this.
Okay, we're not going to take Renee. We're, okay. So, Ms. Skidmore, the next meeting will be at the Parks Task Force on April 4th at 5:30 at the Public Works facility. And Mr. Hermes has talked about redoing the ordinance altogether. All right. Any other discussion on this topic? Okay. No, we're not doing public comment at this meeting. Okay. Do I have a motion that we adjourn? Ms. Reckers, Ms. Kyle, all in favor say aye. Opposed? Motion carried. Have a good evening.